let's go ahead and begin our webinar today. Welcome to the webinar on Legal Planning Essentials for Persons with Dementia, facilitated by the National Alzheimer's and Dementia Resource Center, which consists of our team at RTI International. I'm Sari Schumann with the Resource Center team, and I will be moderating our webinar this afternoon. The purpose of these webinars is to provide helpful, current, and applicable information for ADSSP and ADI SSS grant projects and others in the Aging Network. Please note the webinar today is being recorded, and the PowerPoint presentations will be sent to all of you soon after the webinar. We will allow time for questions through the webinar's chat feature at the conclusion of the presentations. If you have a question during or after the presentations, please enter your questions into the chat feature of the webinar. At this time, I'd like to introduce our speaker today, David Godfrey. David Godfrey is a senior attorney at the American Bar Association Commission on Law and Aging in Washington, D.C. He is responsible for the ABA's role in the Administration on Community Living funded national legal support projects and for producing the ABA National Aging and Law Conference. David's expertise includes planning for incapacity, supported decision-making, retirement income security, legal service delivery, legal ethics, and LGBT aging. Prior to joining the Commission, he was responsible for elder law programming at Access to Justice Foundation in Kentucky. Mr. Godfrey earned his BA with honors at Rollins College in Winter Park, Florida, and his JD cum laude from the University of Louisville School of Law in Kentucky. At this time, I will turn it over to David.
Thank you. It's my pleasure to be here this afternoon. Legal issues in dementia is a deeply important topic. Working with persons and families facing dementia to make sure that the planning for the future is in place and that it gets done as soon as possible. For us, it's really part of person-centered or person-driven care, and this works in very nicely with the concepts of supported decision-making. The basic concepts of supported decision-making is that all adults have a fundamental right to make choices and an ability to do so. Our experience in working with persons with dementia is even individuals with severe limitations still have an ability to express preferences and guide decisions. And with proper planning, the person can select advisors and empower them legally so that as their dementia progresses, the decisions that are made most closely reflect that individual. As adults, we cherish the rights that we have, and yet persons with dementia are routinely asked or forced to give up some of their rights. So I'm going to start with kind of an open question. What's your favorite right? Shane, can you open the first poll? And I'll talk while that continues to work. But there's a broad spectrum of rights and issues that impact every individual. And for most of us, it's really difficult to choose which right do we want to give up or which one is our favorite. And yet these are issues that persons with dementia routinely ask to give up or forced to give up. We can go ahead and close the first poll, and we'll move forward. The kinds of issues or decisions that individuals with dementia face challenges are decisions regarding health, what kind of health care they want or don't want, how it's going to be paid for, managing money, income, making sure that necessary expenses and bills are paid, and simple things like making sure that they retain some autonomy, some right to have spending money, discretionary money where they're able to do what they want to do. Visitation, who do they see, who can't they see, who do they want around or not want around, participation in activities, diet, living arrangements, clothing, travel, and very much a matter of we are our choices and our choices make up a fundamental part of who we are. And on a daily basis, every one of us makes choices about all of these issues. When we're working with persons with dementia and we're talking about planning for changes in memory and cognition, it's important. Timing is very important. First, to start with the fundamental that capacity, the ability to do things, is a spectrum. And we all fall someplace on the spectrum from being incapable to being highly capable, and that's a movable spectrum. It changes over our lifespans and with illnesses that can impact us. Capacity is also very issue-specific, and a good example here, I can drive a car. Haven't hit anything in years. Get it started, get it stopped, get where I want to go, and get back. But I can't fly an airliner. No matter how hard I try, I've just never been able to figure out how to land one. So the fact that I can't fly an airliner doesn't mean I don't have the ability to provide transportation. The point of this is that families, individuals, and communities sometimes are arbitrarily ruled that because a person lacks capacity to do one thing, they lack the capacity to do others. And it's always important when working with individuals with dementia, their family members, and with professionals that are planning in this area to make sure that the capacity assessment is specific to the task or issue that's being dealt with. And that's a wonderful, simple example of just because you can't do one thing doesn't mean you can't do another. It's also important to keep in mind that dementia is progressive and that it will change. And timing is critical at the first signs of changes in memory or cognition. The sooner someone engages in meaningful planning of selecting who their advisors are going to be and legally empowering those advisors so that as memory and cognition change, the planning is already in place. The sooner, the better. The later in the progression of the disease, the more difficult it is to do planning and the less planning that can be accomplished. We've got another poll here. Shane, if you could go ahead and open poll number 2. And the poll is, Andy's doctors have told him that he's experiencing early signs of dementia. What does he need to stop doing? Okay. We'll talk about the options that are managing money. The ability to manage money is frequently one of the first warning signs, or a change in the way someone manages their money is frequently one of the first warning signs of changes in memory and cognition. It's one of the first skill sets or abilities that starts to change. Driving becomes problematic when someone has difficulty finding their way home, or when the disease progresses to the point where they have difficulty in judgment for turning, stopping distances, recognizing obstacles. Really, this is one where I think really the most important thing is being in denial about the change, not being in denial about the changes in memory and cognition and how those are going to impact. And certainly from a lawyer's standpoint, the need for getting involved in doing significant planning so that as the illness progresses, they're able to the maximum extent possible to direct what's going to happen in their future. We can go ahead and close that poll. Thank you. Advanced planning, the obstacles. There is an obstacle to advanced planning for persons with dementia, and that is that the person needs legal capacity to engage in legal planning for incapacity. Assessing capacity is complicated. There's no clear one-size-fits-all, absolute yes-no, bright-line test. There's no simple 10 questions or 20 questions that assess whether someone has capacity or not. A lot of professionals that are on the phone do this work and do it on an ongoing basis and understand the complication of it. The individuals, the persons that we're dealing with, and their family members and their support systems need our help in understanding that there is not an on-off switch, a yes-no switch about capacity. Legal capacity is the ability to understand and communicate a choice. It's more than the ability to simply make a choice, because very late into dementia or other illnesses, people will be able to say yes or no, but it's less complicated than being able to justify the choice. As adults, we're not asked to rationally explain or justify the choices we make. Just think about some of the people I voted for over the years, and if I had to justify some of those votes in various elections, I'd have a really hard time saying that I had the ability to do that. But I was able to make a choice and understand that I was making a choice, and that there were options available, and that I was making a choice there. Capacity is something you kind of know it when you see it. From a medical or a psychosocial standpoint, there's some definitive testing that professionals do that get very well into defining it. An important thing for the person and for their family members and loved ones is to always point out to them that a diagnosis of a change in memory and cognition, a diagnosis of early-stage dementia or Alzheimer's, does not end legal capacity. The assessment of capacity is something that needs to be done on an ongoing and individual basis, recognizing that it will change over time. It'll also change from day to day with the person's with other factors that impact the person. The time of the day, the medication that they're taking, how well they slept last night will impact their capacity. But a diagnosis does not end legal capacity, and that's a big issue or a big struggle that we face with a lot of families and also with a lot of legal professionals in the field that feel that someone has a diagnosis, so they shouldn't be able to do anything anymore, and that's just simply not the issue or not the fact. Characteristics of a dementia-capable legal professional. We've started doing work and trying to train lawyers to be dementia-capable professionals or dementia-capable legal professionals. And the standards there is that they have an understanding of capacity, how to understand it, and how to assess it. They have an understanding of dementia in its various forms. My experience has been dementia doesn't impact two individuals in the same way. If you've seen one person with dementia, you've seen one. Doesn't tell you anything about what the next person is going to be able to do or not be able to do. And as the illness progresses, that's going to change. Dementia-capable legal professionals assess capacity on an ongoing basis, not as a one-time assessment, but every time they meet with the client, they're going to do an individual assessment to see how's the client doing today, what are they understanding, how are they working with it. They're especially skilled in communication, and communicating with a person with dementia as the illness progresses takes unique communication skills. And we do training for lawyers in communication skills of communicating with individuals with dementia or individuals with disabilities to try to improve or to build and develop their communication skills. Dementia-capable legal professionals collaborate with non-legal professionals. When I first started practicing law, I was rather bristling of, we've got social workers out there practicing law without a license, and then one of them pointed out to me one day that I was practicing social work without a license, and if the two of us collaborated together, we'd do a better job of serving our clients than we would if we didn't. And that was a big light bulb come on over the head moment for me. We need to collaborate together across professional lines to provide the highest level of service possible for the clients that we're both there trying to do the best for. Dementia-capable legal professionals understand that there are not just legal issues involved for a person with dementia, but there are also a lot of family issues, social issues that are involved, and they're intertwined and inseparable. Doing legal planning for making healthcare decisions without talking about the family issues and the social issues and the access to care issues and the community issues leaves you with incomplete and insufficient planning. And dementia-capable legal professionals work across the non-legal issues in addition to the legal issues. And they recognize that they'll do as much as they can, and when that's done, we look at alternatives to empowering the individual to make sure that the things that need to be done are done and that the person is protected as necessary. How do you develop relationships with dementia-friendly legal professionals? You get out in the community, you offer cross-training, and you develop the relationships with dementia-capable legal professionals before you need them. So talk to your local bar associations, talk to your local elder law sections. Most state bars have an elder law section or commission or committee, and get to know them and find out who's dementia capable and develop those relationships so that you'll have them as you need them. There's a lot of issues of health care that come up for individuals with dementia, and this is one of the areas where advanced planning can be a huge help in making sure that the healthcare decisions that are made across the spectrum of the person's life reflect the decisions that that person would make if they were able to. A starting point for this is an individual is in control of making their healthcare decisions until their treating physician says they're not or there's a court order. Now, some states require 2 doctors, but generally 1 or 2 doctors saying we don't believe that this patient at this time has the ability to make healthcare decisions for themselves triggers somebody else being able to make healthcare decisions for that individual. It's important for any person who's significantly ill or a person with dementia to let them know that if your doctors are asking your family members and you or ignoring you and making healthcare decisions without you, and you have something to say or input, or you want your opinion to be heard, to speak up. A personal story on this: I had some significant surgery a year ago in May, and came out of surgery with a catheter in. Pretty typical, pretty usual. One of the surgeons came in the next day and said, "Oh, I'll go put an order in the file and in the chart, and we'll get the catheter removed today." And I agreed to that, and everything was fine, and they didn't do it, and lunch came and went, and they didn't do it, and the afternoon progressed, and they came in with the afternoon meds, and I asked about it. And the nurse said, "Oh, I saw the doctor make that note in the chart, and I disagreed with it, so he and I talked about it, and we changed it." If I hadn't spoken up, my voice would not have been heard. I had an opinion on that, and at a very minimum, I thought I should have been consulted or brought into the picture when this choice was being changed. But sometimes it's, I was quite profoundly ill. I'd just come out of major surgery. I was on a lot of pain meds, so they didn't bother to ask. They didn't bother to ask anybody. They just changed it. After I pitched a hissy fit, they didn't do that again. There are, in 44 states, there are statutes on the books that determine if someone can't make a healthcare decision and they haven't designated someone in writing to do so, who can. The surrogate consent laws, we have a chart of them on our website. There's a resource list that will be made available to all the attendees, all the registrants for the webinar, that has a link to that chart. That work, and in the other 6 states, the same thing is done either by practice or tradition. We don't leave people without someone to make healthcare decisions, but there are actually statutes that direct or select who that person is. But we still urge individuals, especially persons with dementia, who know they have this high likelihood of losing the ability to make healthcare decisions on down the road, to name someone in writing to consent to medical treatment when the doctors don't feel comfortable accepting consent from the patient. And that person, the person, their name can be called an agent, a proxy, a surrogate. They're called lots of names. Varies from state to state, and even within an individual state, you'll find that it varies from area to area, hospital to hospital, and doctor to doctor. I really don't care what they're called. But there's someone who's named in a legal document and given the authority to consent for medical treatment when the patient is unable to. Selection of that person is critically important because that's a very, very difficult job, and it requires a few things. They need to be, for a person with dementia, always willing to consult with the person, with the individual, to make sure that the person with dementia is in the loop and being talked to on this. My mother has mid to late stage dementia, was in the hospital 2 or 3 weeks ago, and the doctors were in the room talking with my sister about putting in a feeding tube, and the conversation went on for about 10 minutes, and nobody bothered to look at Mom because, well, she has dementia, and most of the time she can't communicate very well, and suddenly out of the fog she comes up and goes, "No tubes, I want to go home." Why didn't they ask her? She was having a really good day, and she was able to give a very clear and concise answer of what her feelings were at that moment about what they were discussing. So it reinforces why it's always important to consult with the person and find out, do they have a feeling or some input that they want to provide. The healthcare surrogate, proxy, or agent needs to be familiar with the person's healthcare history, with their values, with their beliefs, with their goals, and with what will change, what might trigger a change in that for that person as illness progresses. People who want life-prolonging care will sooner or later reach a tipping point where they say, no, enough is enough, I'm not going to do this anymore. And even those of us who go, well, I don't really want my life prolonged under certain circumstances, will sometimes change our mind and go, no, I really need a couple of more weeks, so whatever you have to do, keep me alive. And you need to know what those tipping points are that'll move a person's wishes regarding this. The agent needs to be willing to act and able to act, and that means they need to be available, and they need to be able to be willing to make choices and make hard choices. And they need to have a lot of strength and a lot of strong character. It's not an easy job. They'll have challenges from other family members, from friends, from healthcare providers, and they're literally making life and death decisions. And some people can do it, and some people can't. And when we say the default surrogate consent laws are not always sufficient, a lot of times for a spouse, it's not possible. It's nothing that they just don't have the strength to do it, and naming someone else can be the ideal or best choice to make sure that the decisions are made when they need to be made. The goal of advanced healthcare planning is to assure that the healthcare choices that are being made, the consent that's being given, is the choice that would be made that the individual, that the person would make if the doctors thought that the person had the ability to make consent. The tools for doing this vary from state to state. Living will directives, powers of attorney for health care, advanced care planning, physician's orders for life-sustaining care. There's all kinds of different forms, and they vary widely from state to state. The commonality in them is that they name a person and legally empower them to make healthcare decisions, and ideally leave some type of instructions or values, goals, beliefs in writing. And there are a handful of specific issues, feeding tubes. There's one specific issue, and that's feeding tubes, that ideally you need something in writing saying, I want a feeding tube or I don't want a feeding tube. That's the one thing that from a lawyer standpoint, if we don't have that in writing, it becomes more difficult if you want to withhold or withdraw a feeding tube under certain conditions. than if you have something in writing saying that you're able to. Critical to the success of any healthcare advanced planning is meaningful conversations about wishes, values, and goals. First, you need to have a conversation with the healthcare agent, with the person you're naming to make healthcare decisions. There are legendary stories of elder law attorneys getting phone calls at 3 o'clock in the morning from the hospital emergency room going, "Hi, your mom is here and we need to figure out whether to hook her up to a respirator or not. She named you as her agent. We have her power of attorney here. What do you want to do?" And the agent not having a clue because they never knew that they'd been named. It's also important to talk to other family members and friends. I used to force my clients to tell the people you didn't name to make your healthcare decisions that you didn't name them and who you did and why. Friends or neighbors or others are going to be heavily involved. And also healthcare providers. It's important to have that conversation with your healthcare providers. Otherwise, they may not even know the paperwork exists. Under recent changes, Medicare is going to start reimbursing some medical expenses or fees for advanced healthcare planning sessions with physicians. I used to tell my clients, when you go in to see your doctor, talk about this issue, stand in front of the door and don't let them out of the room until you've had a chance to tell them what they need to hear, because it's critically important that the healthcare providers be on board. There are a lot of issues with money, receiving income, paying bills, paying for assistance. There are really 3 risks with dementia when it comes to money. Number one, and this is the most common, is mistakes in paying bills or depositing income. My parents came home from lunch one day and the lights had been turned off because Mom hadn't paid the electric bill in 3 months. And it wasn't because there wasn't money in the account. She thought she'd already paid it. That was the first big sign for my father that Mom was having great difficulty in managing money, and when he looked at the checking account, it was horribly out of balance. So that's a huge risk. Financial exploitation, estimates are someplace between 10 and 20% of vulnerable adults are financially exploited. They have money stolen from them by friends and family members, so that's a risk. Rarer, but we do see it, is uncontrolled spending by individuals who develop dementia and are early enough in the process that they're able to go on spending sprees. I had a client one time who bought 3 Cadillac sedan DeVilles in 3 months. It was irrational spending, and if he'd kept doing it that way, he would have spent money that he couldn't afford to spend. So we need to watch for those risks. We have a lot of changes going on, and you can go ahead and open the 3rd poll. In the way we manage money, the banks in Great Britain have announced, and Shane, there we go. The banks in Great Britain have announced that in the next 5 years, they're going to quit processing checks. You're no longer going to be able to write a check there. Most of us today are paid by direct deposit. A surprising number of us are able to pay bills online. And this is changing the way that we can manage money for individuals with dementia. And it's a huge step forward to not have to sit down and make sure that the checks are taken to the bank and deposited, and that the checks are written and the bills are paid. I've sat there with clients and gone through the stack of mail in the dining room table and found checks for thousands of dollars that hadn't been taken to the bank and deposited for an individual who was struggling to put groceries on the table. We can go ahead and close this poll. So it looks like about 95, 96% of us are already doing either direct deposit or paying 1 or more bills online. As this progresses and becomes the norm, it's going to make it easier and easier to manage finances. We have a lot of financial stuff anymore that can be done on autopilot. Putting income on direct deposit. Social Security has mandated this for nearly every Social Security recipient. Pensions, veterans benefits, interest and dividends can generally be direct deposited. Minimum withdrawals from IRAs, 401ks can be set up on direct deposit so that the money is there and it's in the right account. Automatic bill pay for my parents when the lights were turned off. One of the things they did when they went to the electric company to take care of that is the electric company set them up that afternoon so that their electric bill gets paid automatically out of their account. And since then, we've set up so that all of their recurring bills get paid automatically out of their account, including the credit card that they use to pay for groceries gets taken care of automatically. There are other things that are not quite automatic. Adding a trusted signer on a bank or brokerage account. And on this, my note says, plan a backup plan for the backup plan. Just putting one name on there doesn't always work. It really helps to have 2 or 3 names so that if the first choice takes everyone around the world cruise or gets run over by a Mack truck, somebody else is able to help. Online bill pay services with a trusted third party having access. I'm able to monitor the activity in my parents' bank account from 850 miles away by going online and looking at the account. My name is listed on the account. I have access to their online banking, and I'm able to watch what comes in and what goes out to make sure that there aren't any irregularities and to make sure that things that I know should be paid, like the homeowner's insurance that we almost missed recently, do get caught and get paid. There are professional management services that do bill paying and money management services for individuals and can be a great help. Daily money managers, a lot of accountants and bookkeeping offices offer this service. And some really solid faith and community-based organizations offer daily money management services where they sit down and make sure that income is deposited and the bills are paid, and even make sure that the individual has access to spending money in cash. If all else fails for Social Security, there's the Representative Payee Program and the VA Fiduciary Program. Some pension programs have payee options. They're rare, but it's always important to ask. Otherwise, if you've got a pension that's coming in by check rather than by direct deposit, and the person loses the ability to make deposits or sign checks into an account that only has their name on it, it can be difficult. Elder law professionals and social services professionals become quite skilled at figuring out what the options are and how they work. One of the things we urge individuals who are diagnosed with dementia to do is to do a power of attorney for financial and personal decisions. Power of attorney is naming an agent, authorizing somebody and giving them the legal authority to act on your behalf at any time that it's needed. The powers granted in a power of attorney are those granted in the document or by state statute. And the statutes vary widely on this of what the statutory powers are or aren't. Some states list next to nothing. Other states have, I think California statute is 40 pages long. So it goes into a great deal of detail. Again, selection of an agent is critical because the agent needs to be willing and able to act. They need to be trustworthy. Over 90% of the time, nothing goes wrong with a power of attorney, but when it does go wrong, the agent has the ability to misuse or steal the assets. Still, that makes it a crime. They have the ability to do it. It doesn't make it legal for them to do it, and can result in great harm to the individual. And selecting the right agent can be really, really critically important to make sure that the person has low risk of doing something wrong and a high probability of being able to do the right things. Again, in a power of attorney, we try to put in a backup plan of this is the first choice, and if that person is unable or unwilling to act, who's their second choice? The powers that should be included are the powers that the person wants to include. They should have a careful and thoughtful discussion with the attorney that's helping them in drafting the document, or if they're using a state statutory form, and there are a lot of state statutory forms out there, Most of them give you the option of including or excluding particular powers, and they should think, do I want this person to be able to make gifts? Do I want this person to be able to sell my real estate? What do they want the person to be able to do or not want the person to do? And they should make careful choices there and be informed in what they're doing. Powers of attorney must comply with state law, and the laws of what creates an enforceable power of attorney varies from state to state. It is a do-it-yourself project, but it's not a really good do-it-yourself project. I say to do the job and do it right, you probably need to work with a lawyer. With an audience that's largely non-lawyers, an ethics point is avoid the unauthorized practice of law. If your state has a statutory form and you provide the form, that's not the practice of law. If you give them advice about how to fill it out and what boxes to check and what choices to make, that may be interpreted as a practice of law, and that becomes problematic from a regulatory standpoint. And we're also concerned about, are we providing the best service to the client? And it's like a doctor that tries to give medical advice. We should defer to the doctors to give medical advice. They're the ones that have years of training on it. On legal issues, if we defer to the lawyers, they're the ones that have years of training to make sure that it's done in the best possible way. A power of attorney includes managing other assets. Titled personal properties like cars, boats, airplanes. Doing a Medicaid application one time, and we got everything done, and then they came up with well, what about Daddy's airplane? When he retired, he sunk most of his life savings into a new airplane, and we had to deal with making sure that was with how that was allowable and what we could do or couldn't do with it. Household and personal items, valuables. The biggies that we see here in the average family are jewelry and firearms. For a person with dementia and firearms, my first recommendation is get the firearms out of the house. As the disease progresses, the firearms become a risk. They're also valuable, and you want to secure them so that they don't disappear. And the same thing with jewelry, making sure that it's secured, but yet the person doesn't think that someone has stolen it and taken it from them. Trusts, living trusts, or living trusts that are established while a person is alive, may be necessary if the assets are complex. And here we look not just at the value, but the complexity of the assets. People who own a lot of property, a lot of investments, or a lot of valuables may need to enter into a trust agreement, and that's a more complicated legal planning document. And really the issue there is the complexity of the assets more than the dollar amount. If it's all cash in the bank and a house, power of attorney in a lot of cases is going to cover what they need to do. Trusts sometimes become an issue for estate planning purposes because generally they're easier to settle in probate. Our concern is really what's going to happen while this person is still alive more than what's going to happen when this person dies and who's going to inherit what. That's an estate planning question. That's a separate set of questions. But trusts can be a big help while the person is still alive if there are a lot of complex assets. Benefits and insurance, it's important to make sure that the power of attorney includes dealing with Medicare, supplemental health insurance, veterans benefits, the possibility of the need to apply for Medicaid, real and personal property insurance, making sure that the home, the car, the boat, the valuables are insured, life insurance, cash value and beneficiaries. For a lot of low to middle income individuals, life insurance can be their largest single asset other than their home, and it's important to make sure that there are provisions in for that. Include language to make sure the taxes get paid, and there's specific language for the IRS that most attorneys are familiar with. Paying for care or assistance becomes a planning for incapacity for persons with dementia. Home and community-based living is what most people want, and it's important to ask the individual. In the 12,000 clients that I worked with, there were half a dozen that stood out because they said, when I get to the point where I can't take care of myself, I want to be in assisted living or a nursing home because I don't want to be a burden on my family or friends. Far more said, I'd sooner be dead than in a nursing home. So trying to make sure whatever we can do to make sure that the type of care that the individual wants is what's planned for. Medicaid, asset transfer and gift rules need to be considered. Any gifts or transfers for less than fair market value made within 5 years of the time that a person might need to apply for Medicaid can be an issue. The rules are very state specific. This is not something we can do a national webinar on and talk about how the rules work in each state because they vary quite significantly from state to state. But generally speaking, the mistakes that are made by families in financial planning for a person with dementia are giving away money or property without carefully considering if the care needs exceed the ability of the family and other caregivers, the need to apply for Medicaid, and the 5-year look back is a federal rule. And it's always important to remember that 70% of skilled nursing facility care is paid for by Medicaid. There are services we can use to empower individuals with dementia and their families and loved ones to remain in the community. And it's important to remind families and to help connect them with shopping and delivery, getting home-delivered meals, home health assistance, housekeeping assistance, friendly visitors, bill paying, visiting pet services or pet care assistance, transportation, and transportation is a big one, especially in rural areas. Abuse and exploitation is always a concern, so selection of the advisors, the agent and the power of attorney, the second name to add to the bank account is critical. We draft and build in oversight and reporting so that somebody else gets to see a copy of the bank statements, the brokerage statements, somebody else gets to see what's happening. The more eyes and ears that are involved, the less the risk. And it's important to understand what abuse and exploitation is, to raise an objection if you see something that doesn't feel or sound right, and to report it as necessary. Supported decision-making and advanced directives fit together really well for individuals with dementia because of the changes in memory and capacity, but we're starting with an adult who's had a lot of capacity and a lot of ability, and we know we're going to get a gradual loss in the ability to make decisions, to remember things, and to communicate, the progressive nature, because they allow us to document goals, wishes, and values, to select and empower the advisors, to assure that those advisors have been instructed to keep the person at the center of all decisions, and to legally empower those advisors so that if they when they hit challenges to their authority, they've got the legal authority to do it. Sooner or later, the clerk at the bank is going to say, this person doesn't really understand what they're doing well enough, and I'm not going to let them cash that check for $25,000. The agent on the power of attorney or the joint owner on the bank account then is able to step in and help with that. Sooner or later, the doctors are going to say, we don't think this person is able to make their own health care decisions, and having an agent named to make health care decisions is going to help you at that point. Why supported decision-making for persons with dementia? And I'm going to come back to Mom again. Mom, a couple of years ago, spent several weeks in a nursing home. I went in for the family care planning meeting. My oldest brother was there. My father was there. They rolled Mom in and set her at the end of the table. And the nursing home staff comes in with this big smile on their face with the, we've got great news. Joyce is going home on Friday, her 65th wedding anniversary. How wonderful. And my father and my brother and the nursing home staff and I have this wonderful animated conversation about how wonderful that she's going home and home health care and durable medical equipment and what we're going to do. And this conversation went on for about 5 or 6 minutes, and I literally at one point took my palm and slapped myself in the middle of the forehead and go, you know what we've forgotten to do? Look at the end of the table and ask Mom, how do you feel about this? In a supported decision-making, arena, that would have been the place we just would have started instead of the last place we went. Is let's ask Mom, let's find out what she wants to do. What does she think she might need? Does she think she's ready to go? What can we do between now and Friday to make sure that she's ready and that home is ready for her to meet her needs, her wishes, values, beliefs, and goals? Adults are allowed to make bad decisions, so including individuals with dementia are able to make bad decisions. I always contend they should have access, as long as they're able to do something with it, to a little bit of spending money, and to make choices that work for them, and not be criticized about personal relationships or love or where they live, especially if it's a lifelong or long-term condition that other people might think are really bad choices. Adults are allowed to make bad choices. Urge families and friends to be advisors. Start from the perspective that the person can make choices. Always involve the person in choices. Advise them and guide them to let the person make choice. Advise the person and guide the person to make choices, but allow the person to make choices. Look for answers in context. Read body languages and preferences. My mother will sit there and call the dog across the room by going, "Here, kitty, kitty, here, kitty, kitty." And the dog rolls his eyes and then comes over and gets his ears scratched. The words are all wrong, but in context, everybody knows what she means. Even the dogs figured it out. So if we work with families and we suggest to them that looking for using the broadened communication skills, they can continue to communicate with a person with dementia far into the illness. It helps to empower that individual. Guardianship is the last resort. I refer to it as the death penalty of individual rights, only to be done when a person has a severe decline in capacity and is unable to make and communicate decisions. And there's a decision that requires legal authority that must be made, and no one has legal authority to make it. If there's not a legal decision that has to be made where someone lacks authority to do it, there's no reason to file for guardianship just because the person has late-stage dementia or has lost the ability. The other place where guardianship comes in is when all other options have been exhausted, and guardianship is the last resort to protect a person with very limited capacity from abuse, neglect, or exploitation. And they're telling me my time is up and we're ready to go to questions.
Great. Thanks so much for that wonderful presentation, David. Perfect timing. We can move to questions now. I know that quite a few have come in. So you'll notice in the chat feature, you can enter your question into the white box that shows up, and we'll allow people to write some more questions in as I get started asking David. So one person mentioned that getting everything in place early is a great rule of thumb, but what can be done with clients after cognition's already compromised, especially if there's no family to turn to?
Across the development or progression of the illness, it's important to assess the capacity and find what can the person do today and what can't they do. And the capacity that's required for various legal planning varies with what it is. For example, naming someone to make healthcare decisions requires less capacity than creating a trust and transferring assets into it for trust management, for asset management purposes. Generally, if a person says, if I can't make my healthcare decisions, I want this person to do it, that's the capacity you're looking for. They understand that I can't make my decisions, this is who I trust to do it. Where there's not where there's not identifiable friends and family, then it becomes a huge social work issue of digging to find someone who's ready, willing, and able to that already knows this person, hopefully knows some history, or to bring in someone from the social services side as a trained professional who's willing to step in and help.
Great,
and that's
thank you.
a huge issue, and we don't have the resources for everything that we need there.
Sure, thanks so much. There's a few questions that came in. If you can describe the difference between durable power of attorney and attorney in fact.
Okay. A durable power of attorney is a document naming an agent to legally act on behalf of a person. The attorney, in fact, is actually the agent or the person that's named in the document. They're known as an attorney in fact or an agent, but the attorney in fact is the legal description for the person who's named to act on behalf of someone else to act as their agent. There is some minor difference left in state law between a power of attorney and a durable power of attorney, and this is state law specific. In some states, the document requires specific language for it to be usable after the grantor, after the person loses capacity. And that's one of the state-specific things, and it's one of the great risks in pulling a form off of the internet that might not be specific to that state, is if the state has a specific language requirement, it gets missed, and you've created a document that when it's needed doesn't do what's needed. But the power of attorney is actually the paper, and the attorney, in fact, or agent, is the person that's named to act on behalf of the individual.
Great, thank you. Can you talk a little bit about if there's situations that come up if a person with dementia revokes the durable power of attorney, or when a facility requires guardianship if the individual refuses to stay at that facility?
If a person, as long as the person has capacity, they have the legal authority to revoke a power of attorney. And generally speaking, the legal standard for capacity for revoking a power of attorney is going to be fairly low. It's going to be understanding that Sherry's my agent, and I don't want Sherry to do that anymore. I revoke that power of attorney. It's revoked. Some states are going to require that be in writing, and others aren't. It can create a huge problem if this is done by a person who is midway through dementia and has a questionable ability to name someone else. Ideally, if an attorney is involved in the revocation, they're going to want to assess, does the person understand what they're doing, and can we get them to name someone else, especially a person with dementia. It is possible for them it is possible for a person to revoke a power of attorney, and for everyone to agree they really don't have the ability to select another person to help. And then as the illness progresses, that leaves them in this no planning situation where we fall back to the defaults under the statutes, and that's problematic. A person with dementia who's insisting that they're going to leave the nursing home, if they have the ability to say, I don't want to be here and I'm going home, it's legally very difficult to keep them there. Unless their illness has progressed to the point where you can get a state order for involuntary hospitalization, it's not a prison. It's a healthcare facility. And that gets to be really, really complicated, where people insist that they're going to go home and they may not have a home to go home to, or the home that they want to go home to isn't capable, it doesn't have the resources that are necessary for the person to live securely and safely and to have their personal care, nutrition, and medical needs met. But it becomes really difficult to force someone to stay in a nursing home if they're saying, I don't want to stay here, call me a taxi, I'm going home. From a legal standpoint, we know it's done all the time, but if the illness has progressed to the point of qualifying for guardianship, then the guardian has the ability to determine where the person is going to live. Because the guardian steps into the shoes of the individual. And that is, when we're looking at alternatives to guardianship. We're looking at supportive decision-making. It's one of the tipping points where guardianship may become necessary if there's no home to return to, or the home that they want to return to truly cannot meet their care needs, and the illness has progressed to the point where they meet the standards for guardianship in that state, because then the guardian makes that decision, the individual does, if that's what the court has ordered. Does that answer?
I think so. Thanks so much. There's another question here asking about what are some helpful or not so helpful things that healthcare professionals can do to make the legal planning process better or perhaps worse?
Encourage people to do it. Get copies of the documents and put them in the person's medical file. If there's a question about the person's capacity and a medical professional or social work professional has done a professional assessment and they believe the individual has the capacity to make particular choices and decisions, and you're willing to document with the person's permission to share that information so it can be documented into the legal professional's file, that helps the legal professional to be more comfortable and confident in moving forward with planning. I've had clients, when I was practicing law, I had clients who arrived in my office with a letter from the psychologist that they'd seen at 9 o'clock that morning, and their appointment was with me at 10, saying, I've met with my patient, he's having a really good day, and I have no questions about his ability to do estate planning and planning for incapacity today. Document that, get it into the file, and it relieved some of my anxiety about how much time do I need to spend in assessing capacity, and am I going to get a challenge on down the road of, did I help the client in the right way, or did I do the wrong thing by helping a client who really didn't have capacity? There are some, but so that kind of works through the answers for that particular question.
Great, thank you. So what can be done in a situation if a person is spending money on things like gambling, online games, and possibly bouncing other payments? Are there any national resources that can be used to reverse such charges or create controls to stop that kind of spending?
If it's income for Social Security, we start with representative payeeship. It has a relatively low standard, which is that the individual lacks the ability to manage their Social Security benefits and needs somebody else to take over, and the income is diverted to a third party who manages that income and files reports with Social Security. If it's savings and other income, it becomes more complicated, especially if the dementia has not progressed to the point where guardianship becomes an appropriate answer. And the standard for guardianship varies slightly from state to state, but it's really the person's mental or physical condition significantly interferes with their ability to make choices and decisions. I don't know whether, and and beyond that, I'm not sure whether there are other resources to try to do counseling. Again, it's someplace where social service professionals might do a better job of counseling the individual, making sure that they get other family members involved in managing money and resources, getting them to agree with the individuals of how much, what spending money they're going to get available, and that they'll limit their spending to that spending money. I'm not saying cut somebody off, but If all they can afford to lose in the casino is $25 a day, give them $25 a day and let them go play the slot machines if that's what they want to do. But that usually is an agreement situation for an individual with dementia that can be very, very difficult. And we are seeing across the country an increase in individuals who get involved in chronic behavior that costs a lot of money. Casinos are an issue, or gambling is an issue. Sometimes it's online shopping. It's become so easy to go online or the television shopping networks. I've seen clients run up tens of thousands of dollars in credit card bills. The UPS man became their best friend. He showed up every day. He was the only person who came to visit every day. And social service interventions sometimes are more helpful there than legal interventions, especially if the dementia hasn't progressed to the point where it's going to meet the standard for guardianship.
Thank you so much, David. So that's going to close out our webinar today. Thanks everyone for attending. We do have some more questions that folks have put in. You can see in the closing notes. You can contact me, Sari, at my email address that's listed there, or Aaron Long, who is the project officer at the Administration for Community Living. You can also email David Godfrey directly. His email address is there as well. I'll be sending the PowerPoint presentation and the resource list that David mentioned during his presentation to all of you and all the others who have registered for the webinar. And if you have further questions, please don't hesitate to contact us. Thanks everyone for attending, and have a great afternoon.
Thanks.